Swayam Prabha. Digital India. Educated India.
Hello friends, this is lecture 13 under the course Law relating to women and children. In the present lecture, I will focus on the topic law relating to child labour. Child labour is a very significant problem in the life of the children. As we all know that the child or the childhood, it is very sensitive span of life of an individual, and this is also the period of the life where the foundation of learning is laid. This is the time when the children are prepared for their future, not only for their future, but for the future development of a country also, because the children are the greatest asset of any country. The children are the future human resource, and therefore, the growth and development of children is directly related to the development of any country, the development of any nation. When the children are engaged in employments or for the purpose of labor in their early age, then the development, growth, education of those children is impeded, is hampered. And if those children are not properly developed, the growth of the children is hampered. If the proper education and care is not given, then they become subject to the miseries of their life. They become the subject of exploitation, they become the subject of demotivation, they become the subject of non opportunities of the education and development, and in such a manner they are devoid of the basic rights which have been guaranteed by the constitution or which have been guaranteed by the nature itself. Those basic rights or human rights of the children are also compromised when the child labour is practiced. The one important way out or one important method to deal with the problem of child labour or to curb the child labour or eradicate the child labour, the enactment of the law, then the enforcement of that law. So, legislation is one important way out. The legislation, enacting the legislation is one methodology by which the children can be protected against the vice of menace of child labour, and therefore, it is significant for us to know about the law relating to child labour, to see whether the legal provisions which have been enacted by the legislature at union level or state level, they are sufficiently adequate to deal with the problem of child labour. What is the law and whether that law is adequate law? This is very important for the purpose of eradicating the child labour, and this is the reason for which I opted for this topic in relation to this course, the law relating to women and children. And therefore, in the present lecture, we will focus on the law relating to child labour. The employment of the children amounts to denial of rights of future generation and depriving the children of their opportunities to growth. If the children are engaged in the employment at their early age, then certainly they are deprived of the opportunities for the growth, for the development, for the education. This is the same time when they are to devote their time for their further growth, for their basic education, and the parents and society is duty bound to give the proper care to the children at this time, so that they may grow or they may be educated in a proper way, and they may become the efficient or the robust citizens of the country. Working at tender age in hazardous condition, when they are employed in the works, that work may also be the hazardous work. And if the children are employed in hazardous work at this stage, then this employment of the children exposes them to various miseries and hampers their mental, physical, moral and psychological development. As we know that at this age of the childhood, the mind of the children is very soft, and the body also. When they having the very soft mind, then they are always having the likelihood to be influenced by the small things, and when they are engaged in the hazardous works or to work in hazardous conditions, then certainly their mental state, their physical state is affected. So, it hampers their mental, physical, moral and psychological development. The growth and development of the children at this level is hampered if they are engaged or they are employed in the work to do in hazardous conditions. As I have already told you that legislation is one of the effective weapon to end the child labor or to eradicate the child labor. If we want to eradicate the child labor, then certainly the law or the legislation plays an important role, a significant role in this regard, and therefore, the state is always duty bound, is always obliged to enact the laws to eradicate the child labor or for the purpose of eradicating the child labor. India has all along followed a proactive policy in addressing the problem of child labor and has always stood for constitutional, statutory and developmental measures that are required to eliminate the child labor. It means that the Indian state has been very cautious, has been very careful about finding out the measures, about finding out the initiatives, either by way of the constitutional provisions or by way of the legislative initiatives or by way of other administrative measures to deal with the problem of child labor and to protect the children from this vice or this menace of child labor, so that they can grow properly, they can take the education, proper education at this early age of their life. The Constitution of India has relevant provisions to secure compulsory universal primary education. If we refer to Article 21A of Indian Constitution, which has been added by way of 86th Amendment to our Constitution, and the directive principle of state policy, which was falling under Article 45, has been given the shape of fundamental right under Article 21A, and the children are now entitled for their fundamental right to have the education from 6 to 14 years age. One enactment was also made after this amendment in the Constitution. In the follow up of this amendment, the Indian legislature enacted a law, the right to free and compulsory education of children, 2009. And by way of this right to free and compulsory education of children, 2009, the children are given the guarantee to free and compulsory education in the primary schools, in the secondary schools, and the children from 6 to 14 years are given this opportunity. There is one lacuna in this legislation, that the children from 3 to 6 years, which is the age for the preparation for primary education, could not be included within the ambit of the constitutional amendment in the form of Article 21A or within the provisions of right to free and compulsory education of children. But you can see that the constitutional provisions in India, or even the makers of the constitution at the time of making of our constitution, they were very much cautious about the education of children, about the care and development of children, and therefore, they impose the duty on the state in the form of article 45 of Indian constitution, that state would take the effective initiatives at the time of making its policy with regard to the care, development and education of children. Now, the care, education and development of children from 0 to 6 years has been made again the responsibility of state under article 25, article 45, and the article 21A includes the children from 6 to 14 years. India's judiciary right up to take apex level, right up to the apex level, meaning thereby from lower judiciary, from the judiciary at the district level to the apex court, the Supreme Court of India, has demonstrated profoundly empathetic responses against the practice of child labor, because the child labor is very big hindrance in the path of the development, growth and education of children, and therefore, the Supreme Court has also been of the opinion that the child labor must be eradicated. If we talk about the international mandate about the child labor, we can see the International Labor Organization, that is ILO. ILO defines the term child labor as work that deprives children of their childhood, their potential and their dignity, and that is harmful to the physical and mental development. It refers to work that is mentally, physically, socially or morally dangerous and harmful to children, or work whose schedule interferes with their ability to attend regular school, or work that affects their ability to focus during school or experience a healthy childhood. We can see very comprehensive definition, very comprehensive meaning has been given to the term child labor in this ILO convention. International Labour Organization provides for very comprehensive definition, very comprehensive meaning to the term child labor, including all kind of those works and the employment which are injurious to the life of the children. If we analytically see or read or take this meaning or definition of the child labor, it includes many works to be the child labor or to be amounted as the child labor. Work that deprives children of their childhood. The first category of work which is included within the definition, within the ambit and the scope of the meaning of the term child labor is any work that deprives children of their childhood. So, any work which deprives the children from their childhood is in the category of, or it amounts to be the child labor. Their potential and their dignity, any work which deprives the persons, which deprives the children from their potential and their dignity. So, any work which is contrary to the potential of the children, which is contrary to the dignity of the children is the child labor. The work that is harmful to physical and mental development of the children, this is also the child labor. Any work which is harmful to the physical strength or to the mental development of the children is child labor. The child labor refers to work that is mentally, physically, socially or morally dangerous and harmful for children. So, any work which is harmful to the children as to the mental status, as to their physical status, as to their social and moral status, if it is morally dangerous, it is socially dangerous, it is physically dangerous, it is mentally dangerous for the children, then it is certainly the child labor. It also includes the work whose schedule interferes with their ability to attend regular school. This is very important kind of work which is included within the meaning or the definition of child labor. Any such work which interferes the schedule, regular schedule of the children at their school. So, any such work which deprives the children from going to school or which interferes in the regular schedule of their school, that is the child labor. Any work that affects their ability to focus during school, if this work is not interfering in the normal schedule, regular schedule of the school, but if this work in any way affects the ability of the child to focus on their school work, is also the child labor. Or any work which affects the healthy experience of the child is also the child labor. So, many categories of the work have been included within the meaning of child labor by International Labour Organization. A comprehensive definition to the term child labor has been provided. I think that it includes all those works, all those employments, all those labors which are injurious to the mental health, to the physical health, which are injurious to the dignity of the children, which interferes in the right to life and personal dignity of the children, which interferes with the right to education of children, which interferes with the right to development of the children, which interferes with the right to care of the children. These are the within the category of child labor. UNICEF, if we see the definition given by UNICEF, UNICEF defines child labor as involved in child labor activities if between 5 to 11 years of age, he or she did at least 1 hour of economic activity or at least 28 hours of domestic work in a week, and in case of children between 12 to 14 years of age, he or she did at least 14 hours of the economic activity or at least 42 hours of economic activity and domestic work as per week, then it would amount to be the child labor. The India's census 2001 also defines child labor. If we see the definition proposed by India's census 2001 to the term child labor, it provides participation of a child less than 17 years of age in any economically productive activity with or without compensation. So, if any child below the age of 17 years is engaged in any economic activities, either the engagement of the child in economic activities is with the compensation, with the remuneration, or it is without remuneration or without payment, without compensation, it does not matter. What matters? If any child below the age of 17 years is involved, he is engaged in any economic activities, then that would amount to be the child labor. It is irrespective of the fact that the child is paid the compensation, the child is paid the remuneration or not. Such participation could be physical or mental both. The participation or the engagement of the child below the age of 17 years in any economic activities, that participation may be physical, that participation may be mental. So, even the mental engagement, even the mental participation of a child in economic activities with or without compensation, the child who is below the 17 years would amount to be the child labor in accordance with the meaning or definition given by India's census 2001. This definition further states, this work includes part time help or unpaid work on the farm, family enterprise or in any other economic activity such as cultivation and milk production for sale or domestic consumption. So, these works have also been included. It does not require that, does not need that the child is engaged in any organized form of economic activities or organized form of employment. Even if he is engaged in any part time help, he is engaged in any unpaid work on the farm, family enterprise, in any agricultural farm or in any family enterprise, or in any other economic activity such as cultivation and milk production for the sale for the domestic consumption. It is also amount to be the child labor. Indian government classifies child laborers into two groups under this census. What are these two groups? Main workers are those who work 6 months or more per year. So, under the child labor there are two categories: main workers, those who work 6 months or more per year, and marginal child workers, those who work at any time during the year but less than 6 months in a year. So, the criteria or standard has been fixed to classify these two categories of the child workers or child laborers. One, the main workers who work for at least 6 months in a year, and the marginal workers who work at any time, but this working of the children is less than 6 months in a year. Now, see the international legal framework to protect the children from child labor or to deal with the problem of child labor or to eradicate or curb the problem of the child labor. In this series, the Universal Declaration of Human Rights 1948 find the first place. This Universal Declaration of Human Rights was adopted in 1948 by the United Nations General Assembly, and this is the first formal document on the human rights by the United Nations. The United Nations under Universal Declaration of Human Rights opines that it is one of the most important document in international agreement between countries on human rights, including rights of children. Under Universal Declaration of Human Rights, the right to care, right to development, right to education of the children has been guaranteed, and therefore, the child labor is prohibited by this Universal Declaration of Human Rights. When the children are entitled to their natural rights, their human rights, then any such activity which in any way contradicts the basic or natural or human rights of the children goes contrary to the human rights, and it is not acceptable under the regime of Universal Declaration of Human Rights. Then the International Convention on Rights of Child 1989 CRC. CRC recognizes the right of every child to be protected from economic exploitation. The child labor is certainly the economic exploitation of the children, and CRC protects the children from any such economic exploitation and from performing work that is hazardous or harmful to their health and development. The first category of child labor which has been recognized by the International Convention on Human Rights, the International Convention on the Child's of Rights, International Convention on the Rights of Child 1989, the first category of child labor which was recognized is the economic exploitation of the children. The second category, performing work that is hazardous or harmful. Any such work which is hazardous or which is harmful to the health and development of the children would amount to be the child labor, or any such work which interferes with their education. So, any work which causes economic exploitation, any work which is hazardous or harmful to the health and development of the children, and number 3, any such work which interferes with the education of the children is the child labor in accordance with the International Convention on Rights of Child, that is CRC. CRC also requires governments to set a minimum age for employment and to provide for appropriate hours and conditions of employment under Article 32. Under Article 32 of CRC, it is suggested that the nation should come out with the legal provisions making the minimum requirement of minimum age for the employment, so that the children may not be employed by the industries or by the employment. If the state declares a particular age, minimum age for the employment, then certainly the children can be protected from this vice of child labor. The CRC directs the states to provide children with free and compulsory education. This is also the mandate of CRC, that state should give the free and compulsory education to the children. Apart from this, they must encourage the development of secondary education, and apart from this must look into the assistance for those with the capacity of higher education, article 28. Article 28 relies on the education of the children, and states are duty bound under this convention. State parties are duty bound or obliged to ensure the free and compulsory education at primary level, then the promotion of secondary education, and also the opportunities for higher education. Then conventions of the International Labour Organization, ILO or International Labour Organization agreed to, or it came out with several conventions. These conventions are concerning the minimum age for the admission to employment, that is convention number 138, ILO convention number 138, which is concerning to the minimum age for admission to employment, the minimum age for the employment, so that the children may not be employed. Then the ILO convention 182 on the prohibition and immediate action for the elimination of worst forms of child labour, and are the most concrete international agreements on these two international agreements in the form of ILO convention number 138 and ILO convention number 182. These are two important international agreements on combating the child labour. See the ILO conventions on child labour. Convention number 182, that is the worst form of child labour convention. This worst form of child labour convention or the convention number 182 defines various forms of child labour, namely the slavery, debt bondage, pornography, prostitution, forced requirement of children in armed conflict, use of children, drug trafficking, and other hazardous and illicit activities. Any such category of the incidences of the activities are within the scope of the meaning of child labour in accordance with the convention number 182. The minimum age for employment, this is convention number 138, which provides for the minimum age for employment, and this convention providing for the minimum age for employment aims specifically at the minimum age of employment. The gist and relevant points of minimum age convention are: number 1, the minimum age for employment at work is 15 years, whereas if the work is light, and minimum age, whereas the work, when the work is light, then the minimum age may be 13 years. It means that the minimum age for the work has been fixed at 15 years. It also means that no child who is of below 15 years can be employed in any kind of work. Some relaxation has been given if the nature of the work is light, then the minimum age may be 13 years. It means that in any case the child below the 13 years cannot be employed in any work, cannot be expected to do any economic activities. The minimum age for hazardous work is 18 years. This is the third category of minimum age, third feature of this convention. Normally minimum age 15 years, for light work 13 years, and for hazardous work it is 18 years. It may be 16 years under very strict conditions. So, 16 to 18, it means for any hazardous work, in no case any child below 16 years may be involved. The conventions also provide that initially the general minimum age may be 14 years and 12 years for light work at places where the economical and educational development is insignificant. Then what is the constitutional framework in India? If we see the constitutional provisions or the provisions in our constitution with regard to the child labour, article 23 is very important provision. Article 23 of our constitution prohibits traffic in human beings and forced labour. Traffic in human beings and begar and other similar forms of forced labour are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. So, article 23 prohibits the traffic in human beings, it prohibits the forced labor, it prohibits the begar, it prohibits any such other form of forced labor, and it is the mandate of the constitution to the state or to the legislature particularly to come out with the law to declare any such forms of forced labor, begar and traffic as the offence. Article 24, which is said to be the right against exploitation, 23, 24 both, these are the rights in the constitution, rights against exploitation. Article 24 prohibits the employment of children in factories. No child below the age of, according to the article 24, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employments. So, the minimum age for the children to work at factories has been fixed by the constitution itself as 14 years, which is the fundamental law of the land, and even the legislature cannot specify the age below 14 years as the minimum age for the work. Under article 39 E and F, which are the part 4 of our Indian constitution, that is the directive principles of state policy. Article 39 F, E and F, the state shall in particular direct its policy. E says, for securing the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter a vocation unsuited to their age or strength. So, article 39 E mandates that it is the duty of the state to secure the health and strength of workers, men and women, and tender age of children. Tender age children are not allowed, are not abused, and that citizens are not forced by economic necessity. So, the tender age children are not abused for this purpose. 39 F, that children are given opportunity and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. This also aims at the protection of child against the child labor. Now, see the legislative framework in India. What are the legislations or what are the legal provisions, legislative provisions with regard to the eradication of child labor or to deal with the problem of child labor? The Mines Act was enacted in 1952, and under the Mines Act, the minimum age of a person to be employed in a mine has been specified as 18 years. Under subsection 1 of section 40 Mines Act, if we see section 40 of the Mines Act, under subsection Act 1, the minimum age has been fixed as 18 years, meaning thereby that in no mine a child below 18 years, no child can be employed in a mine. Only after attaining the 18 years a person can be employed in a mine in accordance with section 40 subsection 1 of the Mines Act. Now, see section 45 of the Mines Act. It prohibits presence of any person below 18 years of age in any part of the mine above ground where any operation connected with or incidental to any mining operation is being carried on. Not only the employment, but even the presence of the child below 18 years is prohibited by section 45 of the Mines Act. So, the mines owners cannot make the pretense or cannot pretend by using the children for the work at mines and saying that they are only present there. Then the Factories Act 1948, the Factories Act prohibits the employment of children who have not completed age of 14 years. So, under mines, the work of mines is the hazardous work, and therefore, the Mines Act specifies the age, minimum age as 18 years, but in other factories that age may be the 14 years. The Merchant Shipping Act 1958, again the minimum age has been fixed as 14 years. Then the Motor Transports Act 1961, the minimum age has been fixed 14 years. So, in the Factories Act, in Merchant Shipping Act and in Motor Transport Act, the minimum age for the employment of a child is 14 years, whereas in the Mines Act, the minimum age is 18 years. These were the piecemeal provisions which we have seen in different enactments, including the Mines Act 1952. But it was realized that there shall be a comprehensive legislation to deal with the problem of child labour, and therefore, in 1986 the Child Labour Prohibition and Regulation Act was enacted by Indian Parliament. The Child Labour Prohibition and Regulation Act 1986 defines child as a person who has not completed the age of 14 years. You can see that in the legislations other than the Mines Act 1952, the minimum age for a child to be employed in any work was considered to be 14 years, and in Mines Act it was 18 years. Accordingly, the Child Labour Prohibition and Regulation Act specifies the minimum age for the employment of a child as 14 years. It means that any child below 18 years cannot be employed in any kind of employment. Minimum age has been fixed, and then this Child Labour Prohibition and Regulation Act prohibits the employment of children below 14 years in specified occupations and processes. It lays down a procedure to make additions to the schedule of published occupations and processes. Now, see, generally the enactments are made and some items are specified in the schedule to the act. The act either applies to those items in the schedule, or the items in the schedule are exempted from the operation of the act. This is the normal method or methodology of the legislation to enact the laws and to apply these laws to certain transactions, certain commodities, certain individuals or certain organizations or institutions. There is one methodology being adopted by the legislatures at the time of enacting the laws, that the power is delegated to the executive or administrative authorities or the government to make the changes to those schedules, meaning thereby the government can include any new item in the schedule, or the government may exclude any item from the schedule. As it is done by the government, then an item which was under the operation of the, or which was subject to the operation of the enactment, or to which that enactment was applicable, it becomes exempted from the operation, and if any new thing is excluded within the operation of the enactment, then within the schedule, then the matter which was exempted from, or the item which was exempted from the application from the operation of the enactment is now subject to the operation. This is the unique feature of this enactment, that a procedure has been laid down by the enactment itself for making any such additions or for making any such exclusions. It also provides for, or it also regulates the working conditions of the children in occupations where they are not prohibited from working. Some occupations are prohibited, but in some occupations they can be employed, and in the occupations where the children can be employed, the act provides for the conditions of the children in occupations. It regulates the conditions of the work. The enactment lays down penalties of punishment for the term which shall not be less than 3 months, but which may extend to 1 year, or with fine which shall not be less than 10,000 rupees, but which may extend to 20,000 rupees, or with both, and in case of repetition of offences he shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years. So, this punishment has been provided, has been fixed by the enactment, that for the first conviction or first offence, the person shall be punished with 10,000 rupees with the imprisonment of maximum 1 year and minimum 3 months. So, the punishment imprisonment from 3 years to 1 year has been provided, and the fine from 10,000 rupees to 20,000 rupees has been provided, and for the second or subsequent conviction or offence, this punishment is increased up to 2 years and minimum from 3 months to 6 months. Working hours have also been fixed by the enactment. The period of work shall not exceed 3 hours of working time. For the children, the period of the work shall not exceed 3 hours. The maximum period is 3 hours. No child shall be allowed to work for more than 3 hours until the child has taken rest at least of 1 hour. So, 1 hour interval is mandatory. Continuous working shall not be more than 3 hours. Children shall not be allowed to work during the period between 7 p.m. and 8 a.m. That means, the night working is not allowed for the children. From 7 evening up to 8 morning, the children are not allowed to work. Children shall not be allowed to or asked to work for more than 6 hours a day. This also includes 1 hour rest. So, maximum is the 5 hours, and in these 5 hours, 1 hour mandatory break is required for the children. Permission to work overtime shall not be given to children. No child shall be allowed to work at some other place if the child has already worked at some other place for the day. So, if a child work at one place, he is not allowed to work at another place. Number 2, overtime is not allowed. Children shall be allowed 1 holiday every week. The day of the holiday cannot be changed more than once in 3 months. 1 day holiday in a week has been made the right of the working children, and the employer cannot make the change in that day of leisure or that day of holiday more than once in 3 months. Meaning thereby, within 3 months, the employer can change this day only once. The health and safety measures have also been adopted by the Child Labour Prohibition and Regulation Act 1986. What are these health and safety measures? See, the Act provides for better health conditions and health safety for children working in various establishments. This includes proper ventilation in the establishment, free from dust and fumes, proper drinking water and sanitation facilities, proper lighting and proper disposal of waste. Then Child Labour Amendment Act 2016. The enactment which was enacted in 1986, recently in 2016, some amendments were made. What changes have been brought by this amendment in 2016? See, child labour is completely prohibited for children below 14 years. In earlier enactment, we see that in some avocations, the child labour was allowed, and the working conditions, the regulation of working conditions was made. But by 2016 amendments, the child labour is completely prohibited, meaning thereby that the children below 14 years cannot be employed in any work, whether hazardous, or they are only allowed to work in family enterprises after school hours or during vacations. So, whether it was hazardous or not, it does not matter. The children are not allowed to work or to be employed in any employment, in any work. They are only allowed to work in family enterprises after school hours or during vacations. They are allowed to work in family enterprises, but they can work only after the school hours or during the vacations. It includes new section, that is section 3A. This amendment includes makes the addition of section 3A, and this section 3A says that an adolescent is not allowed to work in a hazardous situation. Government will notify the nature of non-hazardous work, such work may be allowed. Now, new section 14 includes penalty in contravention of section 3A, which involves imprisonment for a term of at least 6 months and may extend to 2 years, or with fine at least 20,000 rupees, which may extend to 50,000 rupees. So, fine has also been extended. What are the other changes which include the reduction of the number of hazardous employment from 83 to 3? It is also to be noted that the child rehabilitation fund for those who are victims of child labour is provided. Earlier this arrangement was not there. The penalty is also increased, penalty charges are added to the child rehabilitation fund. What are the policy initiatives in this regard? The National Policy on Child Labour 1987. Through this National Policy on Child Labour 1987, the Government of India recognized and realized that the child labour is the aftermath and the consequence of multiple causes and several factors, and it also has multiple dimensions. Therefore, the eradication of child labour is not possible until these root causes and contributing factors are addressed effectively. Friends, this is the social problem, social and economic problem, and it cannot be curbed or eradicated only by making the laws, only by making the rules, only by enacting the laws. The root causes of the child labour are to be addressed, and these root causes for the child labour are multiple. Multiple factors are responsible for the child labour, and therefore, it was realized under this policy that without addressing these multiple root causes, the problem of child labour cannot be tackled, cannot be eradicated, cannot be curbed only by making the legal initiatives. With this viewpoint, the Government of India came up with the National Policy on Child Labour 1986-7 to deal with problem of child labour with multiple dimensional and multi-layered methodology. The significant pillars of this policy for achieving the objective of eliminating child labour have been as follows. Number 1, legislative action plans. The policy highlights the need of strict and effective enforcement of legal provisions relating to and connected with the child labour. And number 2, convergence of governmental development programs. There may be many governmental programs dealing with the problem of child labour, and the consolidated or integrated effects or initiatives are needed. Therefore, the multiple programs, there should be the convergence in these multiple programs being initiated on the part of the government. The third one is the project based plan of action, finding out the areas of high concentration of child labour and accordingly implementing national child labour project schemes. It is very significant methodology that you first find out the highly concentration, the areas of high concentration of child labour, and focus on those areas by implementing the national child labour project scheme. Only then the problem of child labour may be tackled with. What has been the judicial approach regarding the child labour in India? What is the role of the judiciary and how the judiciary responded to the problem of child labour? The most significant case in this regard was MC Mehta versus State of Tamil Nadu. It was decided in 1996. In this case, the Supreme Court of India has issued certain directions regarding the manner in which children working in the hazardous occupations are to be withdrawn from work, and these are to be rehabilitated. So, for the withdrawal of the children working in hazardous avocations, in hazardous occupations, and the rehabilitation of those children was the point of focus by the Supreme Court in MC Mehta case. The Supreme Court also issued the guidelines to provide for the manner in which the working conditions of the children working in non-hazardous occupations are to be regulated and improved. It was also realized by the apex Indian court, that is the Supreme Court of India, that immediately we cannot eradicate the child labor, problem of child labor absolutely, because this is the social and economic problem, and therefore, the Supreme Court of India issues the directions to provide for the manner in which the working conditions of the children working in non-hazardous occupations are to be regulated. So, the guidelines for the withdrawal of children from hazardous occupations, for their rehabilitation, and the guidelines for providing for the manner for providing for the conditions of the work if the children are employed in non-hazardous works. The judgment of the Supreme Court of India in MC Mehta case includes simultaneous action in all districts of the country, survey for identification of working children, withdrawal of children working in hazardous industries and ensuring their education in appropriate institutions, contribution of rupees 20,000 per child to be paid by the offending employers of children to welfare fund to be established for this purpose, employment to one adult member of the family of the child so withdrawn from the work, and if that is not possible, a contribution of rupees 5,000 to the welfare fund to be made by the state government, financial assistance to the families of the children so withdrawn from hazardous occupations to be paid out of the interest earnings on the corpus of rupees 20,000, 25,000 deposited in the welfare fund as long as child is actually sent to the schools, regulating hours of work for children working in non-hazardous occupations so that their working hours do not exceed 6 hours per day, and education for at least 2 hours is ensured per day. The entire expenditure on education is to be borne by the concerned employer. Planning and preparedness on the part of central and state governments in terms of strengthening of the existing administrative regulatory enforcement framework. These guidelines were issued by the Supreme Court in MC Mehta case, and if we see these guidelines issued by the Supreme Court, it seems that if these guidelines are applied or enforced in their content and spirit, then certainly we can deal with the child labor, problem of child labor effectively, and we can ensure the rights of the children. We can withdraw the children from the hazardous occupations, and we can also address the economic necessities of those families who involve their children for the economic necessity in such hazardous occupations. We can also provide for the working conditions of the children. We can ensure the education of those children who are employed in non-hazardous occupations. Thank you.
Hello and welcome to this piece of literary snippet. Today we are going to read a section from Virginia Woolf's novel Orlando, and the section that we are going to listen to today is perhaps one of the finest descriptions of the winter season in English literature. It is also a very fine piece of what we call fantasy writing. I have made a few changes to the original to adapt it for the purpose of reading. The great frost was historians tell us, the most severe that has ever visited these islands. Birds froze in mid-air and fell like stones to the ground. At Norwich, a young countrywoman started to cross the road in her usual robust health and was seen by the onlookers to turn visibly to powder and be blown in a puff of dust over the roofs. The mortality among sheep and cattle was enormous. Corpses froze and could not be drawn from the sheets. It was no uncommon sight to come upon a whole herd of swine frozen immovable upon the road. The fields were full of shepherds, ploughmen, teams of horses, and little bird-scaring boys, all struck stark in the act of the moment. One with his hand to his nose, another with a bottle to his lips, a third with a stone raised to throw at the ravens who sat upon the hedge within a yard of him as if they were stuffed birds. The severity of the frost was so extraordinary that a kind of petrification sometimes ensued. It was commonly supposed that the great increase of rocks in some parts of Derbyshire was due to no eruption, for there was no eruptions. Rather, it was supposed that they were due to the solidification of unfortunate wayfarers who had been turned literally to stones where they stood. The church could give little help in the matter, and though some landowners had these relics blessed, the most part preferred to use them either as landmarks, scratching posts for sheep, or when the form of the stone allowed, drinking troughs for cattle, which purpose they serve admirably for the most part to this day. But while the country people suffered the extremity of want, and the trade of the country was at a standstill, London enjoyed a carnival of utmost brilliance. The new king directed that the river, which was frozen to a depth of 20 feet, should be swept, decorated, and given all the semblance of a park or pleasure ground, with arbors, mazes, alleys, drinking booths, all at his expense, of course. Frozen roses fell in showers when the Queen and her ladies walked abroad. Colored balloons hovered motionless in the air. Here and there burnt vast bonfires of cedar and oak wood, lavishly salted so that the flame were of green, orange, and purple fire. But however fiercely they burnt, the heat was not enough to melt the ice, which, though of singular transparency, was yet of the hardness of steel. So clear, indeed, was the ice that there could be seen, congealed at a depth of several feet, here a porpoise, there a flounder. Shoals of eels lay motionless in a trance, but whether their state was one of death or merely of suspended animation which the warmth would revive, puzzled the philosophers. In short, nothing could exceed the brilliancy and gaiety of the scene by day. But it was at night that the carnival was at its merriest. The nights were of perfect stillness. The moon and stars blazed with the hard fixity of diamonds, and to the fine music of flute and trumpet the courtiers danced. See you in the next episode of Literary Snippet.